Q. Santa Monica Plywood Corporation entered into a contract with Arnold for the milling of lumber as well as the hauling of waste wood products. The company provided the equipment and tools because Arnold had neither tools and equipment nor capital for the job. Arnold, on the other hand, hired his friends, relatives, and neighbors for the job. Their wages were paid by Santa Monica Plywood Corporation to Arnold based on their production or the number of workers and the time used in certain areas of work. All work activities and schedules were fixed by the company. Is Arnold a job contractor? No. In two cases decided by the Supreme Court, it was held that there is job contracting, where the contractor carries on an independent business and undertakes the contract work in his own account, under his own responsibility according to his own manner and method, free from the control and direction of his employer or principal in all matters connected with the performance of the work except as to the result thereof. And two, the contractor has substantial capital or investment in the form of tools, equipment, machineries, work premises, and other materials which are necessary in the conduct of his business. Lim versus NLRC. In the problem given, Arnold did not have sufficient capital or investment for one. For another, Arnold was not free from the control and direction of Santa Monica Plywood Corporation because all work activities and schedules were fixed by the company. Therefore, Arnold is not a job contractor. He is engaged in labor-only contracting. Q. Empire Brands. Empire contracted the services of Style Corporation, Style, for the marketing and promotion of its clothing line. Under the contract, Style provided Empire with trade merchandising representatives, TMRs, whose services began on September 15, 2004, and ended on June 6, 2007, when Empire terminated the promotions contract with Style. Empire then entered into an agreement for manpower supply with Wave Human Resources, or Wave. Wave owns its condo office, owns equipment for the use by the TMRs, and has assets amounting to $1 million. Wave provided the supervisors who supervise the TMRs, who in turn receive orders from the marketing director of Empire. In their agreement, the parties stipulated that Wave shall be liable for the wages and salaries of its employees or workers, including benefits and protection due them, as well as remittance to the proper government entities of all withholding taxes, Social Security Service, and PhilHealth premiums in accordance with relevant laws. As the TMRs wanted to continue working at Empire, they submitted job applications as TMRs with Wave. Consequently, Wave hired them for a term of 5 months, or from June 7, 2007 to November 6, 2007, specifically to promote Empire's products. When the TMR's 5-month contracts with Wave were about to expire, they sought renewal thereof, but were refused. Their contracts with Wave were no longer renewed as Empire hired another agency. This prompted them to file complaints for illegal dismissal, regularization, non-payment of service incentive leave, and 13-month pay against Empire and Wave. Are the TMRs employees of Empire? 2016. Yes, from the time Empire contracted the services of Style, both engaged in labor-only contracting. In BPI Employees Union, Davao City, FUBU versus BPI, it was ruled that where any of the following elements is present, there is labor-only contracting. A. The contractor or subcontractor does not have substantial capital or investment which relates to the job, work, or service to be performed, and the employees recruited, supplied, or placed by such contractor or subcontractor are performing activities which are directly related to the main business of the principal. Or B. The contractor does not exercise the right to control over the performance of the work of the contractual employee. The first element is present herein, as Style has no substantial capital or investment in engaging in the supply of services contracted out by Empire, which is directly related to the marketing and promotion of its clothing line. The second element is present, as it is inevitable for Empire to direct the activities of the TMRs to properly market and promote its product line. The subsequent contract of Empire with Wave did not affect the regular employment of the TMRs with Empire, as to the marketing director of Empire. The TMRs were under the control of Empire. Thus, the 5-month employment contract entered into by the TMRs with Wave did not divest them of their regular employment status with Empire. In addition, such a scheme undermined the security of tenure of the TMRs, which is constitutionally guaranteed. Hence, the contract of the TMRs with Wave is void ab initio. Solidarity liability. Q. Antonio Antukin, a security guard, was caught sleeping on the job while on duty at the Yossi cigarette factory. As a result, he was dismissed from employment by the Wagon Security Agency, an independent contractor. At the time of his dismissal, Antonio had been serving as a watchman in the factory for many years, often at stretches of up to 12 hours, even on Sundays and holidays without overtime, nighttime, and rest day benefits. He thereafter filed a complaint for illegal dismissal and non-payment of benefits against Yossi Cigarette Factory, which he claimed was his actual and direct employer. As the labor arbiter assigned to hear the case, how would you correctly resolve Antonio's claim for overtime and other benefits? Antonio's claim for overtime and other benefits should be paid by Yossi Cigarette Factory. The Labor Code provides that in the event that the contractor or subcontractor fails to pay the wages of his employees, the employer shall be jointly and severally liable to the extent of the work performed under the contract in the same manner and extent that he is liable to employees directly employed by his contractor or subcontractor for any violation of any provisions of the Labor Code. Manpower Inc. (CMI) had provided janitorial services to the National Economic Development Authority (NEDA) since April 1988. Its service contract was renewed every 3 months. However, in the bidding held on July 1992, CMI was disqualified and excluded. In 1993, 6 janitors of CMI formerly assigned at NEDA filed a complaint for underpayment of wages. Both CMI and NEDA were impleaded as respondents for failure to comply with NCR wage orders number 01 and 02, which took effect on November 1, 1990 and January 2, 1992 respectively. Should NEDA, a government agency subject to budgetary constraints, be held liable solidarily with CMI for the payment of salary differentials due to complainants? Cite the legal basis. NEDA shall be held solidarity liable with CMI for the payment of salary differentials due to the complainants because NEDA is the indirect employer of said complainants. The Labor Code provides that a person, partnership, association, or corporation, which not being an employer, contracts with an independent contractor for the performance of any work, task, job, or project, shall be jointly and severally liable with his contractor or subcontractor to such employees of the contractor or subcontractor to the extent of work performed under the contract. Articles 106 and 107 of the Labor Code. Termination of employment, 2015. Q. Gabriela Liwanag has been working as a bookkeeper at Great Foods Incorporated, which operates a chain of high-end restaurants throughout the country since 1970, when it was still a small eatery at Binondo. In the early part of the year 2003, Gabriela, who was already 50 years old, reported for work after a week-long vacation in her province. It was the height of the SARS, Severe Acute Respiratory Syndrome (SCAR), and management learned that the first confirmed SARS death case in the Philippines is Balikbayan nurse from Canada, is a townmate of Gabriela. Immediately, a memorandum was issued by management terminating the services of Gabriela on the ground that she is a probable carrier of SARS virus and that her continued employment is prejudicial to the health of her co-employees. Is the action taken by the employer justified? The employer's act of terminating the employment of Gabriela is not justified. There is no showing that said employee is sick with SARS or that she associated or had contact with the deceased nurse. They are merely townmates. Furthermore, there is no certification by a competent authority that the deceased is of such a nature or such a stage that it cannot be cured within a period of 6 months, even with proper medical treatment. Implementing Rules, Book 6, Rule 1, Section 8, Labor Code. Rico has a temper, and his work as division manager at Matatag Insurance frequently loses his temper with his staff. One day, he physically assaults his staff member by slapping him. The staff member sues him for physical injuries. Matatag Insurance decides to terminate Rico after notice and hearing on the ground of loss of trust and confidence. Rico claims that he is entitled to the presumption of innocence because he has not yet been convicted. Comment on Matatag's action in relation to Rico's argument. Matatag Insurance does not have to await the result of the criminal case before exercising its prerogative to dismiss. Dismissal is not affected by a criminal case. Under the threefold liability rule, a single act may result in three liabilities, two of which are criminal and administrative. To establish them, the evidence of the crime must amount to proof beyond reasonable doubt, whereas the evidence of the ground for dismissal is substantial evidence only. In this regard, the company has some basis already for withholding the trust it has reposed on its manager. Hence, Rico's conviction need not precede the employee's dismissal. Termination by employee. Q. An accidental fire gutted the JKL factory in Caloocan. JKL decided to suspend operations and requested its employees to stop reporting for work. After 6 months, JKL resumed operations but hired a new set of employees. The old set of employees filed a case for illegal dismissal. If you were the labor arbiter, how would you decide the case? 2014. I will rule in favor of the employees. JKL factory merely suspended its operations as a result of the fire that gutted its factory. Article 286 of the Labor Code states that an employer may bona fide suspend the operation of its business for a period not exceeding 6 months. In such a case, there would be no termination of the employment of the employees, but only a temporary displacement. Since the suspension of work lasted more than 6 months, there is now constructive dismissal. Cebuguero versus NLRC. Q. RS. A security guard filed a complaint for illegal dismissal against Star Security Agency. He alleged he was constructively dismissed after 10 years of service to the agency, having been placed on off detail and floating status for 6 months already. He claimed the agency just really wanted to get rid of him because it required him to take a neuropsychiatric evaluation test by Mahusay Medical Center. RS said he already submitted the result of his evaluation test by Brent Medical Clinica, precondition to a new assignment, but the report was rejected by the agency. RS added that Mahusay Medical Center had close ties with STAR's president. It could manipulate tests to favor only those guards whom the agency wanted to retain. STAR defended its policy of reliance on Mahusay Medical Center because it has been duly accredited by the Philippine National Police. It is not one of those dubious testing centers issuing ready-made reports. STAR cited its sad experience last year when a guard ran amok and shot an employee of a clerk of a client bank. STAR claimed management prerogative in assigning its guards and prayed the RS complaint be dismissed. What are the issues? Identify and resolve them. On the first issue, there is constructive dismissal. RS cannot be placed on off detail and floating status indefinitely. If it lasts for more than 6 months, RS shall be deemed to have been constructively dismissed, thus entitling him to separation benefits. Superstar Security Agency versus NLRC. On the second issue, there is no valid exercise of management prerogative. STAR's claim of management prerogative in assigning its guards cannot be exercised to defeat or circumvent RS's right to security of tenure. Q. Lincoln was in the business of trading broadcast equipment used by television and radio networks. He employed Nell as his agent. Subsequently, Lincoln set up Liberty Communications to formally engage in the same business. He requested Lionel to be one of the incorporators and assigned him 100 Liberty shares. Lionel was also given the title Assistant Vice President for Sales and Head of Technical Coordination. After several months, there were allegations that Lionel was engaged in under-the-table dealings and received confidential commissions from Liberty's clients and suppliers. He was therefore charged with serious misconduct and willful breach of trust and was given 48 hours to present his explanation on the charges. Lionel was unable to comply with a 48-hour deadline and was subsequently barred from entering company premises. Lionel then filed a complaint with the labor arbiter claiming constructive dismissal. Among others, the company sought the dismissal of the complaint, alleging that the case involved an intra-corporate controversy which was within the jurisdiction of the regional trial court. If you were the labor arbiter assigned to the case, how would you rule on the company's motion to dismiss? 2014. I will deny the motion to dismiss. Corporate officers, in the context of Presidential Decree Number 902-A, are those officers of the corporation who were given that character by the Corporation Code or by the corporation's bylaws. Section 25 of the Corporation Code enumerates 3 specific officers that in law are considered as corporate officers: the President, Secretary, and the Treasurer. Lincoln is not one of them. There is likewise no showing that his position as Assistant Vice President is a corporate officer in the company's bylaws. The labor arbiter therefore has jurisdiction over the case. Article 217, letter A, paragraph 2, Labor Code. Q. Distinguish between dismissal of an employee for just cause and termination of employment for authorized cause. Enumerate examples of just cause and authorized cause. Dismissal for a just cause is founded on faults or misdeeds of the employee. Separation pay as a rule will not be paid. Examples: serious misconduct, willful disobedience, commission of crime, gross and habitual neglect, fraud, and other causes analogous to the foregoing. Article 282 Labor Code. Termination for authorized causes are based on business exigencies or measures adopted by the employer, not constituting faults of the employee. Payment of separation pay at varying amounts is required. Examples: redundancy, closure, retrenchment, installation of labor-saving device, and authorized costs. Article 283 to 284 Labor Code. Q. Arnaldo, president of Bisig Union in Firmware Company, readied himself to leave exactly at 5 p.m., which was the end of his normal shift, to be able to send off his wife, who was scheduled to leave for overseas. However, the general manager required him to render overtime work to meet the company's export quota. Arnaldo begged off, explaining to the general manager that he had to see off his wife, who was leaving to work abroad. The company dismissed Arnaldo for insubordination. He filed a case for illegal dismissal. Decide. Arnaldo cannot be dismissed for insubordination. This is so because one of the requisites for insubordination is absent. It cannot be said that Arnaldo's conduct was characterized by a wrongful and perverse attitude. Arnaldo can be said to have been motivated by his honest belief that the order was unreasonable because he had to send off his wife, who was scheduled to leave for overseas. Q. Sergio, an employee of Encantado Philippines, EPI, was at the company canteen when Corazon, a canteen helper, questioned him for his use of somebody else's identification card, ID. Sergio flared up and shouted at Corazon's, "Wala kang pakialam. Kung gusto mo, itapon ko itong mga pagkain ninyo." When Sergio noticed that some people were staring at him rather menacingly, he left the canteen but returned a few minutes later to remark challengingly, "Sino ba ang nagagalit?" Sergio then began smashing some food items that were on display for sale in the canteen, after which he slapped Corazon, which caused her to fall and suffer contusions. The incident prompted Corazon to file a written complaint with Gustavo, the the personal manager of API, against Sergio. Gustavo required Sergio to explain in writing why no disciplinary action should be taken against him. In his written explanation, Sergio admitted his misconduct but tried to explain it away by saying that he was under the influence of liquor at the time of the incident. Gustavo thereafter issued a letter of termination from the employment of Sergio for serious misconduct. Sergio now files a complaint for illegal dismissal, arguing that his acts did not constitute serious misconduct that would justify his dismissal. The acts of Sergio constituted serious misconduct, thus there was just cause for his termination. The fact that he was under the influence of liquor at the time that he did what he did does not mitigate, instead it aggravates his misconduct. Being under the influence of liquor while at work is by itself serious misconduct. Q. Roman had been a driver of Double 10 Corporation for 10 years. As early as his 5th year in the service, he was already commended as a model employee and given a salary increase. On his 7th year, he became a steward of his labor union. Since then, he became disputatious and obstinate, and his performance fell below par. One day, his manager told him to pick up some documents from a certain bank which were needed to close a business transaction. Roman did not obey. He said he had an important personal engagement. Moreover, he did not want to drive a vehicle that was not air-conditioned. When his immediate supervisor asked him in the afternoon to drive an air-conditioned car, Roman again refused. He said he did not want to drive as he wanted to leave the office early. Roman was asked to explain. After hearing his explanation, Roman was dismissed for willful disobedience. Roman filed a case for illegal dismissal against the Double 10 Corporation with prayer for reinstatement and full back wages without loss of seniority rights, plus moral and exemplary damages and attorney's fees. Roman contended that since there was no emergency situation and there were other drivers available, his refusal to drive for the manager and later for his supervisor was not serious enough to warrant his dismissal. On the other hand, he claimed that he was being punished because of his activities as a steward of his union. If you were the labor arbiter, would you sustain Roman? Discuss fully. If I were the labor arbiter, I will not sustain Roman. It is true that it would be an unfair labor practice for an employee to discriminate against his employee for the latter's union activities. But in the case, the corporation is not discriminating against Roman because he is a union official. When the manager of Roman told him to pick up some documents from a certain bank, this was a lawful order, and when Roman did not obey the order, he was disobedient. And when he disobeyed a similar request made later in the afternoon of same day, he was guilty of willful disobedience to do what management asked him to do. This is just cause for his termination. Q. Jose and Erica, former sweethearts, both worked as sales representatives for Magna, a multinational firm engaged in the manufacture and sale of pharmaceutical products. Although the couple had already broken off their relationship, Jose continued to have special feelings for Erica. One afternoon, Jose chanced upon Erica riding in the car of Paulo, a co-employee and Erica's ardent suitor. The two were on their way back to the office from a sales call on Silver Drug, a major drug retailer. In a fit of extreme jealousy, Jose rammed Paulo's car, causing severe injuries to Paulo and Erica. Jose's flare-up also caused heavy damage to the two company-owned cars they were driving. As a lawyer for Magna, advised the company on whether just and valid grounds exist to dismiss Jose. Jose can be dismissed for serious misconduct, violation of company rules and regulations, and commission of a crime against the employer's representatives. Article 282 of the Labor Code provides that an employer may terminate an employment for any serious misconduct or willful disobedience by the employee of the lawful orders of his employer or his representatives in connection with his work. Misconduct involves the transgression of some established and definite rule of action, forbidden act, a dereliction of duty, willful in character, and implies wrongful intent, and not mere error in judgment. For misconduct to be serious and therefore a valid ground for dismissal, it must be 1. Of grave and aggravated character and not merely trivial or unimportant, and 2. Connected with the work of the employee. B. Assuming this time that Magna dismissed Jose from employment for cause and you are the lawyer of Jose, how would you argue the position that Jose's dismissal was illegal? 2013. The offense committed by Jose did not relate to the performance of his duties. For misconduct or improper behavior to be a just cause for dismissal, it must be 1. Serious, B. Must relate to the performance of the employee's duties, and C. Must show that the employee has become unfit to continue working for the employer. On the basis of the foregoing guidelines, it can be concluded that Jose was not guilty of serious misconduct. Jose was not performing official work at the time of the incident. Lagrosas versus Bristol Myers. Additionally, there was no compliance with the rudimentary requirements of due process. Oscar Pimentel was an agent supervisor rising from the ranks in a corporation engaged in real estate. In order to promote the business, the company issued a memorandum to all agent supervisors requiring them to submit a feasibility study within the respective areas of operation. All agent supervisors complied except Oscar. Reminded by the company to comply with the memorandum, Oscar explained that being a dropout in school and uneducated, he would be unable to submit the required study. The company found the explanation unacceptable and terminated his employment. Aggrieved, Oscar filed a complaint for illegal dismissal against the company. Decide case. For failure to comply with the memorandum to submit a feasibility study on his area of operation, Oscar cannot be terminated, presumably for insubordination or willful disobedience, because the same envisages the concurrence of at least 2 requisites. 1. The employee's assailed conduct must have been willful or intentional, the willfulness being characterized by wrongful and perverse attitude. 2. The order violated must have been reasonable or lawful, made known to the employee, and must pertain to the duties which he had been engaged to discharge. In the case at bar, at least 2 requisites are absent, namely, Oscar did not willfully disobey the memorandum with a perverse attitude, and 2. The directive to make a feasibility study did not pertain to his duties, hence, the termination for employment of illegal Pimentel is not lawful. Q. Domingo, a bus conductor of San Juan Transportation Company, intentionally did not issue a ticket to a female passenger, Kim, his longtime crush. As a result, Domingo was dismissed from employment for fraud or willful breach of trust. Domingo contests his dismissal, claiming that he is not a confidential employee and therefore cannot be dismissed from the service for breach of trust. Is Domingo correct? Reasons. Domingo, as bus conductor, holds a position wherein he was reposed with the employer's trust and confidence. In Bristol Myers Squibb versus Baban, the court established a second class of positions of trust that involve rank-and-file employees who, in the normal and routine exercise of their functions, regularly handle significant amounts of money. A bus conductor falls under such second class of persons. This does not mean, however, that Domingo should be dismissed. In Etcoban versus Sulpicio, the court held that where the amount involved is minuscule, an employee may not be dismissed for loss of trust and confidence. Q. Lance was a strict and a popular vice president for sales of Robinson's land. One day, Lance shouted invectives against Lee, a poor-performing sales associate, calling him, among others, a brown monkey. Hurt, Lee decided to file a criminal complaint for grave defamation against Lance. The prosecutor found probable cause and filed an information in court. Robinsons decided to terminate Lance for committing a potential crime and other illegal acts prejudicial to business. Can Lance be legally terminated by the company on these grounds? No. The grounds relied upon by Robinsons are not just causes for dismissal under the Labor Code. Defamation is not a crime against person, which is a ground to dismiss under Article 282, now Article 295, letter D of the Labor Code. Q. What are the authorized causes for a valid dismissal by the employer of an employee? Why are they distinct from the just causes? The authorized causes for a valid dismissal are the following: installation of labor-saving devices, B. Redundancy, C. Retrenchment to prevent losses, D. The closing or cessation of operation of the establishment or undertaking. The authorized causes for a valid dismissal are distinct from just causes because where the dismissal of an employee is based on just causes, these just causes are acts committed by the employee which provided the basis for his dismissal. On the other hand, where the dismissal is based on authorized causes, these authorized causes are the result of the proper exercise by the employer of his management prerogatives. If a valid dismissal is based on just causes, there is no liability on the part of the employer, although sometimes financial assistance to be given to the dismissed employee is asked of the employer. If a valid dismissal is based on authorized causes, the employer has to pay separation pay, except in case of closure or cessation of operation due to serious losses or financial reverses. Q. What conditions must prevail and what requirements, if any, must an employer comply with to justify or affect a valid retrenchment program? In the case of Asian Alcohol Corporation versus NLRC, the Supreme Court stated that the requirements for valid retrenchments must be proved by clear and convincing evidence. 1. That the retrenchment is reasonably necessary and likely to prevent business losses, which, if already incurred, are not merely de minimis, but substantial, serious, actual and real, or if only expected, are reasonably imminent, as perceived objectively and in good faith by the employer. 2. That the employer serve written notice, both to the employees and to the Department of Labor and Employment at least 1 month prior to the intended date of retrenchment. 3. That the employer pays the retrenched employees separation pay equivalent to 1 month pay or at least 1 month pay for every year of service, whichever is higher. 4. That the employer exercises its prerogative to retrench employees in good faith for the advancement of his interests and not to defeat or circumvent the employee's right to security of tenure. And 5. That the employer used fair and reasonable criteria in ascertaining who would be dismissed and who would be retained among the employees, such as status, whether they are temporary, casual, regular, managerial employees, efficiency, seniority, physical fitness, age, and financial hardship for certain workers. Q. Hagibis Motors Corporation, Hagibis, has 500 regular employees in its car assembly plant. Due to the Asian financial crisis, Hagibis experienced very low car sales, resulting to huge financial losses. It implemented several cost-cutting measures, such as cost reduction on use of office supplies, employment hiring freeze, prohibition on representation and travel expenses, separation of casuals, and reduced work week. As counsel for Hagibis, what are the measures the company should undertake to implement a valid retrenchment? 2016. For a valid retrenchment, the following requisites must be complied with. A. The retrenchment is necessary to prevent losses and such losses are proven. B. Written notice to the employees and to the dole at least 1 month prior to the intended date of retrenchment. And C. Payment of separation pay equivalent to 1 month pay or at least 1/2 month pay for every year of service, whichever is higher. Jurisprudential standards for the losses which may justify retrenchments are, firstly, the losses expected should be substantial and not merely de minimis in extent. If the loss purportedly sought to be forestalled by retrenchment is clearly shown to be insubstantial and inconsequential in character, the bona fide nature of the retrenchment would appear to be seriously in question. Secondly, the substantial loss must be reasonably imminent, as such imminence can be perceived objectively and in good faith by the employer. Thirdly, because of the consequential nature of retrenchment, it must be reasonably necessary and is likely to be effective in preventing the expected losses. Lastly, alleged losses, if already realized and the expected imminent losses sought to be forestalled, must be proven by sufficient and convincing evidence. Manatad versus Philippine Telegraph and Telephone Corporation. Hagibis should exercise its prerogative to retrench employees in good faith. It must be for the advancement of its interests and not to defeat or employees' right to security of tenure. Hagibis should use fair and reasonable criteria such as status, efficiency, seniority, physical fitness, age, and financial hardship for certain workers, in ascertaining who would be dismissed and who would be retained among the employees. Daisy's department store hired Leo as a checker to apprehend shoplifters. Leo later became chief of the checkers section and acquired the status of a regular employee. By way of a cost-cutting measure, Daisy decided to abolish the entire checkers section. The services of Leo, along with those of his co-employees working in the same section, were terminated on the same day. A month after the dismissal of Leo, Daisy engaged the services of another person as an ordinary checker and with a salary very much lower than that which Leo used to receive. Given the above factual settings, nothing more having been established, could the dismissal of Leo be successfully assailed by him? Yes, given the factual setting in the problem and since nothing more have been established, the dismissal of Leo can be successfully assailed by him. This is so because the burden of proof is upon the employer to show compliance with the following requisites for reduction of personnel. 1. Losses or expected losses should be substantial and not merely de minimis. 2. The expected losses must be reasonably imminent, and such imminence can be perceived objectively and in good faith by the employer. 3. It must be necessary and likely to prevent the expected losses. The employer must have taken other measures to cut costs other than labor costs. And 4. Losses, if already realized, or the expected losses, must be proved by sufficient and convincing evidence. Lopez Sugar Corporation versus Federation of Sugar Workers. Moreover, the notice requirements to be given by Daisy's department store to Dole and the employees concerned 30 days prior to the intended date of termination, as well as the requisite separation pay, were not complied with. Q. ABC Tomato Corporation, owned and managed by 3 elderly brothers and 2 sisters, has been in business for 40 years. Due to serious business losses and financial reverses during the last 5 years, they decided to close the business. As counsel for the corporation, what steps will you take prior to its closure? As counsel for the corporation, I will see to it that the corporation shall serve a written notice at its intended date of closing or cessation of operation on the workers of the corporation and the Department of Labor and Employment at least 1 month before the intended date of closure or cessation of operation. Are the employees entitled to separation pay? The employees of the corporation are not entitled to separation pay because Article 283 of the Labor Code expressly provides that if the closure or cessation of operation of an establishment is due to serious business losses or financial reverses, the employees are not entitled to separation pay. If the reason for the closure is due to old age of the brothers and sisters, is the closure allowed by law? Yes, the closure is allowed by law. For a bona fide reason, an employer can lawfully close shop at any time. Just as no law forces anyone to go into business, no law can compel anybody to continue the same. It would be stretching the intent and spirit of the law if the courts interferes with management's prerogatives to close or cease its business operations just because the business is not suffering from any loss or because of the desire to provide workers continued employment. Alahang Country Club, versus NLRC. Q. Siena Corporation or Siena informed the Department of Labor and Employment Regional Director of the end of its operations. To carry out the cessation, Siena sent letter requests for intervention to the NLRC for permission and guidance in effecting payment of separation benefits for its 50 terminated employees. Each of the terminated employees executed a quit claim and released before labor arbiter Nakamura, to whom the case was assigned. After the erstwhile employees received their separation pay, the labor arbiter declared the labor dispute dismissed with prejudice on the ground of settlement. Thereafter, Siena sold all of its assets to Sandro Company, which in turn hired its own employees. Nell Lee, one of the 50 terminated employees, filed a case for illegal dismissal against Siena. She argued that Siena did not cease from operating since the corporation subsists as Sandra. Nelly pointed out that aside from the two companies having essentially the same equipment, the managers and owners of Sandra and Siena are likewise one and the same. For its part, Siena countered that Nelly is barred from filing a complaint for illegal dismissal against the corporation in view of her prior acceptance of separation pay. Is Nelly correct in claiming that she was illegally dismissed? No. In SME Bank versus de Guzman, October 8, 2003, there are two types of corporate acquisitions, asset sale and stock sales. In asset sales, the corporate entity sells all or substantially all of its assets to another entity. In stock sales, the individual or corporate shareholders sell a controlling block of stock to new or existing shareholders. Asset sale happened in this case, hence, Siena is authorized to dismiss its employees but must pay separation pay. The buyer Sandra is not obliged to absorb the employees affected by the sale, nor is it liable for the payment of their claims. The most that Sandra may do, for reasons of public policy and social justice, is to give preferences in hiring qualified separated personnel of Siena. Distinguish between the substantive and the procedural requirements for the dismissal of an employee. This is the substantive requirement for the valid dismissal of an employee. There should be a just cause for the termination of an employee or that the termination is authorized by law. This is the procedural requirement. The employer should furnish the employee whose employment is sought to be terminated a written notice containing a statement of the causes for termination, and the employer should afford the employee to be terminated ample opportunity to be heard and to defend himself with assistance of his representative if he so desires. Articles 279 and 277 Labor Code. Twin notice requirement. Q. Assuming the existence of valid grounds for dismissal, what are the requirements before an employer can terminate the services of an employee? A. Assuming that there is a valid ground to terminate employment, the employer must comply with the requirements of procedural due process, written notice of intent to terminate stating the cause for termination, hearing and notice of termination. The Labor Code reads, Notice and hearing. 277 Miscellaneous provisions. The employer shall furnish the worker whose employment is sought to be terminated a written notice containing a statement of the causes for termination and shall afford the latter ample opportunity to be heard and to defend himself with the assistance of his representative if he so desires. The Supreme Court ruled in Salau versus NLRC, not only must the dismissal be for a valid or unauthorized cause as provided by law, but the rudimentary requirements of due process, notice and hearing must also be observed before an employee must be dismissed. The Supreme Court in Tanala versus NLRC, in a long line of earlier case ruled, this court has repeatedly held that to meet the requirements of due process, the law requires that an employer must furnish the workers sought to be dismissed with two written notices before termination of employment can be legally effected. That is, 1. A notice which apprises the employee of the particular acts or omission for which his dismissal is sought, and 2. subsequent notice after due hearings, which informs the employee of the employer's decision to dismiss him. Q. Alfredo was dismissed by management for serious misconduct. He filed suit for illegal dismissal, alleging that although there was maybe just cause, he was not afforded due process by management prior to his termination. He demands reinstatement with full back wages. What are the twin requirements of due process which the employer must observe in terminating or dismissing an employee? The twin requirements of due process are notice and hearing to be given to the worker. There is likewise a two-notice requirement rule, with the first notice pertaining to specific causes or grounds for termination, and a directive to submit a written explanation within a reasonable period. The second notice pertains to a notice of termination pursuant to Perez versus Philippine Telegraph and Telephone Company. The court held that a hearing or conference is not mandatory as long as the employee is given ample opportunity to be heard. Example, any meaningful opportunity, verbal or written, to answer the charges against him or her and submit evidence in support of the defenses, whether in a hearing, conference, or some other fair, just, and equitable way. Q. Inday was employed by Herrera Home Improvements as interior decorator. During the first year of her employment, she did not report for work for 1 month. Hence, her employer dismissed her from the service. She filed with the labor arbiter complaint for illegal dismissal, alleging she did not abandon her work and that in terminating her employment, Herrera Home deprived her of her right to due process. She thus prayed that she be reinstated to her position. Inday hired you as counsel. In preparing the position paper to be submitted to the labor arbiter, explained the standard of due process which should have been observed by Herrera Home in terminating your client's employment. The Labor Code provides the following procedure to be observed in terminating the services of an employee based on just causes as defined in Article 282 of the Code. A. A written notice must be served on the employee specifying the ground or grounds for termination and giving him reasonable opportunity within which to explain his side. B. A hearing or conference shall be conducted during which the employee concerned, with the assistance of counsel if he so desires, is given an opportunity to respond to the charge, present his evidence, or rebut the evidence presented against him, and C. A written notice of termination must be served on the employee indicating that upon due consideration of all the circumstances, grounds have been established to justify his termination. Q. Attorney Olisa heads the legal department of Company X with the rank and title of Vice President. During his leave of absence, his assistants took over as acting head of the legal department. Upon his return, Attorney Olisa was informed in writing that his services were no longer needed, it appearing that the company had lost so many cases by default due to his incompetence. Attorney Olisa filed a case for illegal dismissal. Will his case prosper? His case will prosper. He was not given procedural due process. He was not given the required notice, namely a written notice containing a statement of the causes for termination, and he was not afforded ample opportunity to be heard and to defend himself. But if before the labor arbiter, in a hearing of the case of illegal dismissal that Attorney Olisa may have filed, he is found to be grossly incompetent, this is just cause for his dismissal. Article 277. B. Labor Code. Q. Joseph Villriolo, JV, a cashier of Seaside Sunshine Supermart, SSS, was found after an audit to have cash shortages on his monetary accountability, covering a period of about 5 months in the total amount of $48,000. SSS served upon JV the written charges against him via a memorandum order of preventive suspension, giving JB 24 hours to submit his explanation. As soon as JB submitted his written explanation within the given period, the same was deemed unsatisfactory by the company, and JB was peremptorily dismissed without any hearing. The following day, his termination from employment. JB filed a case of illegal dismissal against SSS. During the hearing before the labor arbiter, SSS proved by substantial evidence JB's misappropriation of company funds and various infractions detrimental to the business of the company. JB, however, contended that his dismissal was illegal because the company did not comply with the requirements of due process. Did SSS comply with the requirement of procedural due process in the dismissal from employment of JB? In connection with the right to due process in the termination of an employee, the Labor Code requires that the employer furnishes the worker whose employment is sought to be terminated a written notice containing a statement of the causes of termination and shall afford ample opportunity to be heard and to defend himself with the assistance of his representative if he so desires. SSS did not comply with the above described requirements for due process. The memorandum order was for the preventive suspension of JB, not a notice for his termination and the causes of his termination. Discuss briefly the instances when non-compliance by the employer with a reinstatement order of an illegally dismissed employee is allowed. Despite a reinstatement order, an employer may not reinstate an employee in the following instances. A. When the position or any substantial equivalent thereof no longer exists. B. When reinstatement has been rendered moot and academic by supervening events such as insolvency of the employer as declared by the court or closure of the business. C. The existence of strained relations between the employer and the illegally dismissed employee, provided the matter is raised before the labor arbiter. In the event that reinstatement is no longer feasible, or if the employee chooses not to be reinstated, the employer shall pay him separation pay in lieu of reinstatement pending appeal. Q. A strike was staged in Mela Corporation because of a deadlock in CBA negotiations over certain economic provisions. During the strike, Mela Corporation hired replacements for the workers who went on strike. Thereafter, the strikers decided to resume their employment. Can Mela Corporation be obliged to reinstate the returning workers to their previous position? Yes. Mela Corporation can be obligated to reinstate the returning workers to their previous positions. Workers who go on strike do not lose their employment status except when, while on strike, they knowingly participated in the commission of illegal acts. The Labor Code expressly provides, mere participation of a worker in a lawful strike should not constitute sufficient ground for termination of his employment, even if a replacement had been hired by the employer during such lawful strike. Q. Eduardo Santiago, a project worker, was being assigned by his employer, Bagsak Builders, to Lawag, Ilocos Norte. Santiago refused to comply with the transfer, claiming that, in effect, constituted a constructive dismissal because it would take him away from his family and his usual work assignments in Metro Manila. The labor arbiter found that there was no constructive dismissal, but ordered the payment of separation pay due to strained relations between Santiago and Bagsak Builders, plus attorney's fees equivalent to 10% of the value of Santiago's separation pay. Is the award of attorney's fees valid? State the reasons for your answer. Yes. What Article 111, letter B prohibits is the demand or acceptance by any person in a judicial or administrative proceedings for the recovery of wages, attorney's fees, which exceeds 10% of the amount of wages recovered. Since in this case the amount of attorney's fees is exactly equivalent to the 10% of the separation fee recovered, the award is valid. B. Could the labor arbiter have validly awarded moral and exemplary damages to Santiago instead of attorney's fees? No. In the case of Lirug Textile Miles et al. Versus Court of Appeals, the Supreme Court held that when the termination of the services of an employee is attended by fraud or bad faith on the part of the employer, as when the latter knowingly made false allegation of a supposed valid cause when none existed, moral and exemplary damages may be awarded in favor of the former. In this case, there was no showing that there was a bad faith on the part of the employer. In fact, The bad faith and false allegations were on the part of the employee when he refused to obey the transfer mandated by his employer solely on the shallow basis that he will be away from his family. Q. What damages can an illegally dismissed employee collect from his employer? An illegally dismissed employee may collect from his employer actual and compensatory damages, moral damages, and exemplary damages, as well as attorney's fees as damages. Q. Lyric Theatre Corporation issued a memorandum prohibiting all ticket seller from encashing any check from their cash collections and requiring them instead to turn over all cash collections to the management at the end of the day. In violation of this memorandum, Melody, a ticket seller, encashed 5 checks from her cash collection. Subsequently, the checks were dishonored when deposited in the account of Lyric Theatre. For this action, Melody was placed under a 20-day suspension and directed to explain why she should not be dismissed for a violation of the company's memorandum. In her explanation, she admitted having encashed the checks without the company's permission. While the investigation was pending, Melody filed a complaint against Lyric Theatre for back wages and separation pay. The labor arbiter ordered Lyric Theatre to pay Melody $115,420, representing separation pay and back wages. The NLRC affirmed the ruling of the labor arbiter. Is the ruling of the NLRC correct? 2002. The ruling of the NLRC affirming the labor arbiter's decision ordering Lyric Theatre to pay $115,420, representing separation pay and back wages, is wrong. The labor arbiter's decision is wrong because A. It is premature. There was still no termination. All that was done by the employer, Lyric Theatre, was to place the employee under a 20-day suspension. Meanwhile, directing her to explain why she should not be dismissed for violation of company's memoranda. B. The order for Lyric Theatre to pay separation pay has no factual basis. Separation pay is to be paid to an employee who is terminated due to the installation of labor-saving devices, redundancy, retrenchment to prevent losses, or the closing or cessation of operation or the establishment undertaking. None of these events has taken place. Neither is separation pay here in lieu of reinstatement applicable because there is just cause if Melody is terminated under the circumstances. C. The order for the Lyric Theatre to pay back wages has no factual basis either, because there is just cause if she will be terminated after investigation. In this case, there is willful disobedience by the employee of the lawful orders of her employer in connection with her work. She did not just violate the lawful order of the employer. She violated it 5 times. Melody did not give any justifiable reason for violating the company's memorandum prohibiting the encashment of checks. Joe Cinema Corporation versus Avellana. Q. A. An employee of Company B was found to have been illegally dismissed and was ordered to be reinstated and paid back wages from the time of dismissal until actual reinstatement. The case was elevated all the way to the Supreme Court. By the time the Supreme Court's decision became final and executory, B had closed down and was in the process of winding up. Nonetheless, B paid A's back wages and separation pay. A complaint that B's computation was erroneous in that A's allowance was not included. Is A correct in his claim? For what reason? A is correct. Article 279 provides that an employee who is unjustly dismissed from work shall be entitled to reinstatement without loss of seniority, rights, and other privileges, and to his full back wages, inclusive of allowances, and to his other benefits, or their monetary equivalent, computed from the time his compensation was withheld from him up to the time of his actual reinstatement. Clearly, based from the foregoing provision, A is entitled to his allowances. Q. As a rule, when is retirement due? Article 287 provides for 2 types of retirement. A. Optional retirement, which may be availed by an employee reaching the age of 60. B. Compulsory retirement, which may be availed by an employee upon reaching the age of 65. In both instances, the law imposes the minimum service requirement of 5 years with the establishment. When is retirement due for underground miners? Pursuant to RA 8558, in the absence of a retirement plan or other applicable agreement providing for retirement benefits of underground mine employees in the establishment, any such employee may retire upon reaching the age of 50 years or more if he has served for at least 5 years as underground mine employee or in underground mine of the establishment. Q. Ricky Mervyn had worked for more than 10 years in IGB Corporation under the terms of the personal policy on retirement, and any employee who had reached the age of 65 and completed at least 10 years of service would be compulsorily retired and paid 30 days pay for every year of service. Ricky Mervyn, whose immigration visa to the USA had just been approved, celebrated his 60th birthday recently. He decided to retire and move to California, where the son who petitioned him had settled. The company refused to grant him any retirement benefits on the ground that he had not yet attained the compulsory retirement age of 65 as required by his personal policy. Moreover, it did not have a policy on optional or early retirement. Taking up the cudgels for Ricky Mervyn, the union raised the issue in the grievance machinery. As stipulated in the CBA, no settlement was arrived, and the matter was referred to voluntary arbitration. If you were the voluntary arbitrator, how would you decide? I would grant Ricky Mervyn the retirement benefits under Article 287 of the Labor Code. Article 287 of the Labor Code, as the minimum standard in law, allows an employee an optional retirement upon reaching the age of 60 years old, provided he rendered at least 5 years of service, requirements that Ricky Mervyn met under the facts of the case. Q. After 30 years of service, Beta Company compulsorily retired Albert at age 65 pursuant to the company's retirement plan. Albert was duly paid his full retirement benefits of 1 month pay for every year of service under the plan. Thereafter, out of compassion, the company allowed Albert to continue working and paid him his old monthly salary rate, but without the allowances that he used to enjoy. After 5 years, under this arrangement, the company finally severed all employment relations with Albert. He was declared fully retired in a fitting ceremony, but the company did not give him any further retirement benefits. Albert thought this treatment unfair as he had rendered full service at his usual hours in the past 5 years. Thus he filed a complaint for the allowance that were not paid to him, and for retirement benefits for his additional 5 years, based either on the company's retirement plan or the retirement pay law, whichever is applicable. Is he entitled to additional retirement benefits for the additional service he rendered after age 65? No, he cannot be compulsorily retired twice in the same company. That's it. 2013 bar. Q. A collective bargaining agreement between Company A and its employees provides for optional retirement benefits for employees who have served the company for over 25 years, regardless of age, equivalent to 1.5 months' pay per year of service based on the employee's last pay. The CBA further provides that employees whose service are terminated, except for causes, shall receive said retirement benefit regardless of age or service record with the company or to the applicable separation pay provided by law, whichever is higher. The company, due to poor business conditions, decided to cease separation and gave its employees the required 1 month's advance notice as well as notice to dole, with the further advice that each employee may claim his corresponding separation or retirement benefits, whichever is higher, after executing the required waiver and quit claim. Dino Ramos and his co-employees, who have all rendered more than 25 years of service, received their retirement benefits. Soon after, Ramos and others similarly situated demanded for their separation pay. The company refused, claiming that under the CBA they cannot receive both benefits. Who is correct? The employees are correct. In the absence of a categorical provision in the retirement plan and the CBA that an employee who receives separation pay is no longer entitled to retirement benefits, the employee is entitled to the payment of both benefits pursuant to the social justice policy. Conrado Aquino et al. Versus National Labor Relations, February 1999.